Contracts govern countless business relationships, but what happens when those relationships need to end? A properly drafted termination clause can be the difference between a clean break and a messy legal battle. Termination clauses are essential components of any contract that outline how and when parties can legally end their agreement. These provisions serve as an exit strategy, providing clarity and protection for all involved parties. At its core, a termination clause allows parties to end a contract lawfully under specific conditions. Contracts can terminate in several ways: through mutual agreement, breach of contract, impossibility of performance, or simply by reaching their expiration date. A well-crafted termination clause offers multiple benefits. It provides clarity and predictability by outlining exactly how a contract can end. It helps manage risk by enabling parties to exit relationships that no longer serve their interests. It offers legal protection by establishing clear grounds for termination, and it provides business flexibility, allowing organizations to adapt to changing circumstances. Without a termination clause, ending a contract prematurely becomes significantly more complex and legally risky. Every effective termination clause contains several key elements. First are termination triggers, the specific conditions that allow one or both parties to end the contract. These might include material breach, insolvency, or force majeure events. Notice requirements specify the process for providing written notification of termination, including timelines such as 30 or 60 days notice. The clause should also detail post-termination remedies and obligations, what each party must do after termination, such as making final payments or returning confidential information. Termination clauses typically distinguish between termination for cause and termination for convenience. Termination for cause occurs when one party materially breaches the contract or fails to perform. Termination for convenience allows a party to exit the agreement without cause, usually with advance notice. Many clauses include cure periods, giving the breaching party time to fix issues before termination can occur. Survival clauses specify which contract terms continue after termination, such as confidentiality obligations. Termination clauses come in several common forms. Termination for cause is triggered by serious contract breaches. Termination for convenience allows ending the contract without cause. Automatic termination occurs when predefined conditions are met, such as project completion. Mutual termination happens when both parties agree to end the contract without dispute. Other types include termination upon notice, termination on insolvency or bankruptcy, and termination due to force majeure events like natural disasters. When drafting termination clauses, certain mistakes frequently arise. Overly broad or ambiguous language can lead to disagreements about what qualifies as grounds for termination. Omitting cure periods may unnecessarily escalate conflicts. Unrealistic notice timelines can create logistical challenges. Ignoring local laws is problematic since some jurisdictions restrict certain termination provisions. Missing post-termination details regarding data, payments, or intellectual property can lead to compliance risks. To draft effective termination clauses, follow these best practices. Use clear, specific language and avoid vague terms like material breach without context. Include detailed notice provisions specifying how notice must be given and the required advance time. Address the consequences of termination, such as return of property or final payments. Tailor the clause to the specific contract type, as different agreements require distinct approaches. Ensure your clause complies with relevant laws, especially in international agreements. Void contracts lack essential elements for enforcement or are otherwise unlawful. Examples include unsigned contracts, agreements involving minors, fraudulent contracts, or agreements for illegal activities. There are multiple ways to terminate a contract legally. If performing the required obligations becomes impossible, you can terminate based on impossibility of performance. Breach of contract occurs when one party intentionally fails to meet obligations, though this method isn't recommended. Prior agreements between parties may call for termination under specific circumstances. Rescission can occur when a party misrepresents themselves, makes a mistake, or acts illegally. And of course, contracts terminate once all obligations are fulfilled. Understanding termination clauses is crucial for anyone entering into contractual relationships. These provisions provide the roadmap for ending agreements legally and efficiently, protecting all parties involved. By including clear, comprehensive termination terms, you can manage legal risk, maintain business continuity, and ensure smooth transitions when business relationships conclude. Remember that termination clauses should be reviewed by qualified legal counsel to ensure they're valid and enforceable under the relevant jurisdiction's contract law. With proper attention to detail, your termination clause can provide the security and clarity needed for confident business relationships.